The one piece of advice is whether you have a plan or not, you always need to be thinking about contacting an attorney. If you don't have a plan, get one in place. If you have one, maybe it's time to review it. Have your situations changed? Have you had life changes? Have your assets changed? And even if they haven't, it's a good idea to, look at that plan every 3 or 4 years anyway. So my advice is everyone needs a plan. And even if you have one, you need to be reviewing it to make sure it's still, meeting all of your goals.
You're listening to the Isn't That Rich podcast, and we're your hosts, Jill Franks
and Ashley McVicker. As young females in the banking industry, we love simplifying the confusing yet everyday questions you have about money.
Like, how do I get my finances in order?
Where is my money really going?
How do I invest for my future?
How do I make my money work for me?
Can I really afford to buy that new home?
These are the questions that keep us up at night, and the truth is no one was born knowing how to handle their finances.
And chances are walking into a bank to ask for help seems intimidating.
Whether you're a single person in your early 20s saving for your first home,
or you're an empty nester wondering what to do with that extra spending cash,
this is the podcast for you.
Believe it or not, you have an estate. In fact, nearly everyone does. Your estate consists of everything you own, to your car, your home, other real estate, checking and savings accounts, investments, life insurance, furniture, personal possessions. No matter how large or how modest, everyone has an estate and something major in common. You cannot take it with you when you go. But when it does happen, you want to make sure you can control those things that are passed down to the people or organizations you care about the most. And in order to ensure that happens, you need to take steps on how to make carrying out your plan as easy as possible. Our guest today is an expert when it comes to estate planning, and that's why we knew he would be the perfect person for our podcast today. Evan Taylor is a lawyer at Lawler Brown here in Marion, Illinois. Evan concentrates on the areas of complex estate planning, probate, guardianship estates, business law, personal injury, real estate law, and when Evan is not working, he enjoys spending time with his two daughters, his wife, working in his wood shop, and volunteering in a variety of activities as a member of his church. Evan, thank you so much for coming. Welcome.
Thank you for having me. Thanks for the introduction as well. That was great.
Yeah. So how long have you been here in Marion? Because originally, Evan, you're not from Southern Illinois.
Yeah, that's correct. From East Tennessee, originally from the Gatlinburg area. If any of you have ever vacationed there, that's where I grew up.
It's beautiful.
That's where I'm from.
How could
Absolutely.
you leave?
A lot of people there is the only issue. And I came up here for law school in 2006. I graduated in 2009 from SIU. School of Law. While I was in school here, I met my wife. She's from Marion, and so that's why I'm still here. Yeah,
Okay.
I'm raising a family here. I love it here. It's a great area. I love it. I love what I do, and I'm glad I can be here to share it with you guys.
Absolutely. So today we're talking all about estate planning, and you're an expert in that area.
Expert is a strong word, but I have been doing it a long time, and I do feel confident in what I do. I do it every day. I'm meeting with people all the time in various stages of life that, like you said, everyone has an estate. There's no estate too large, too small, and everyone needs at least a basic plan. And so that's what I'm doing day in and day out, is meeting with people, finding out where they are in life, finding out what kind of planning they have, if any, and taking it from there. Yeah.
That's perfect. Well, we have lots of questions, and I know our listeners have a lot of questions as well.
Absolutely.
So let's jump into it. What is an estate, and why do I need a plan in place?
Yeah, so an estate essentially consists of a person's assets. Those can come in many forms. Often dealing with real estate, specifically in this area, real estate, farms, rental properties, things like that. But it's also your investment accounts, your 401ks, traditional IRAs, bank accounts, your personal property. That's often more important to people than you would even think, making sure that goes to the right person. So your tangible things, your jewelry, things like that. Yeah. So any assets that you have consist of your estate. And as far as your probate estate, that consists of the estate we need to handle through a probate court or that goes through a will. There we're talking about assets that are just in your name with no designated beneficiary on it. So an estate is what you own, but from a legal standpoint, if it's your estate for probate purposes, it's things that are structured just in your name with no beneficiary on them.
Okay, I'm going to stop you right there because a lot of people don't know what probate means.
It's a very common misconception. It's often used kind of as a bad word as
Yeah.
well. Probate, we don't want to go to probate. Then often people are like, well, why don't we want to go to probate? And what is probate? So yeah, it is something. It's one of the things that I mainly talk about in that first meeting. I do free consultations with clients. They come in, I want to know why they're there, what brought them there, what triggered them finally reaching out to an attorney to get this done, because people often put this off for a long time because it's not something you want to think about, go through. You don't want to talk about your death, plan your death, things like that. So with probate, though, that's usually one of the foremost kind of concerns in people's mind. They've probably experienced it through a family member or a friend. They've seen them have to go to court, go through that process, and they want to know what they can do to try to avoid that. So every estate, when we talk about the estate earlier, it has to be settled, meaning you have to collect the assets. You have to figure out how they're supposed to be distributed, whether there's a plan or not. You have to pay any last creditors. That settlement of the estate can be either inside the court or outside the court. When we talk about probate, we're just talking about that inside the court settlement of an estate.
Okay.
So is that what happens when someone dies without a will, or?
That is what most people think, and that kind of leads to another, common misconception. A lot of people think if they have a will, that's going to avoid probate. I've said what I want. Why do I need to go to court? And that's often something, I deal with families coming in a lot of times after someone's passed away, whether they've done planning or not, they want to know, what do I do now? And they'll bring in that will. They'll be like, that's what he said he wanted. He put me in charge. He says it goes to these people. How do I cut the checks? Well, then we have to start talking through the assets, because probate is all about your assets and how they're held. It really has nothing to do with the documents you have in place, though you do need those documents in place, and you need them to work with your financial plan, with your assets, to make sure you avoid probate. The automatic triggers, what gets most estates into probate in the state of Illinois, it's usually one of two things that I see. If you pass away with real estate just in your name, we're going to have to probate your estate. If you pass away with other assets totaling over $100,000 just in your name, no designated beneficiary, that also triggers a probate. So it's really not about the documents, about your assets and how you have them structured.
That's interesting. I wouldn't have thought that. So if my home is only in my name, that will go into probate.
That is correct. So
Wow.
yeah, in any initial consultation, I'm not just talking to them about what kind of documents they need. I'm talking to them, I'm going through their assets with the client, and ultimately, if they hire me and we move forward, I'm making a spreadsheet of every asset they have, approximately what it's worth, and we're making a to-do list. You don't need to do anything with this. You need to change the beneficiary designation on this, going through it item by item just to make sure everything's getting taken care of.
You mentioned beneficiaries, and this is something we talk about a lot with bank accounts,
Sure.
is
Yeah.
the importance of having those beneficiaries on the account.
Right.
And so if people do have these beneficiaries set up, can they avoid that sort of thing?
Absolutely.
Okay.
Any account that has a beneficiary on it does not go towards that $100,000 threshold. So a beneficiary designation is a great way to avoid probate. It's not always necessarily the best way. Some issues you can have if you've just got beneficiary designation set up is that doesn't account for if your beneficiary is a minor. We may want to structure things to protect that minor and give them money over time, which we can do through estate planning. If that person's disabled for various reasons, we may not want them to just get an outright distribution from a beneficiary designation. So sometimes it's better to have assets go through your estate plan, maybe fund them to a trust that protects for minor beneficiaries or disabled beneficiaries.
That's interesting. I didn't even think of that, of people with disabilities, how that
Right.
changes things. So you mentioned a will,
Yes.
and you mentioned that it's not the same thing as setting up an estate. So you have your piece of paper as your will. So people need a will.
Yes. Yeah.
And can you maybe explain the importance of a will, and then maybe go into what it looks like to estate plan further than just having a will.
Yeah, absolutely. A will is still a great document, even though it doesn't necessarily in and of itself avoid probate, but I still consider that the foundational document of any estate plan, and I think everyone at a bare minimum should at least have a will, because if nothing else in that will, you're getting to a point you're an executor in that will, so who's going to handle your estate, pay your last remaining debts, distribute what assets are going through that will. They could be the person that ends up handling your funeral arrangements and things like that. The will, you can also, what's very important, especially for younger people that I meet with that have minor children, is in your will you can name who would be the guardians of those minor children if something happened to you. And sometimes what's more important to people is to name who they don't want to be their guardian.
Yeah.
There may be someone they don't want stepping in and taking care of their kids. So anytime I'm meeting with a younger couple or a younger person, that's normally one of their primary concerns, is what is going to happen to my minor children if something happens to me. And in a will, I can put those guardianship provisions in that will.
Wow. Wow. Yeah. That I understand that. When my family was a minor, we had an accident, and that was one of the things. My father was in the hospital for a long time. My mother passed away. And so just seeing that firsthand, there was nothing set up. Right. They were 42, they were young, had an entire life ahead of them. And so when they didn't have that in place, man, it sure would have been much easier on the entire family had that been there. So that's so important.
It's just great to have that specificity and have it all in place so that it's not just all open-ended to where people can argue, fight, question what you wanted, who should be in charge. Yeah.
Right. And you mentioned guardianship. So for your children to know where to go should something like that happen.
Yes.
What about pets?
Pets, that's a popular one too. And I think if my wife had her way, our dog would probably be the primary beneficiary of everything we have. So pets are very important. It's often, sometimes overlooked some in planning. People, are thinking a lot about the kids, who's going to be in charge, what's going to happen to their assets. But pets are very important as well. And you can name who you would want to take care of your pets. I would normally leave that kind of open-ended to, whatever pets you have at that time. Something I've not seen as often, but I have done it a few times, is that you can even do pet trusts. So you can have a trust set up for your pet to provide money for them, for the remainder of their life, and then that kind of thing. That's not something I've done as much, but it certainly happens, and I completely understand it.
Well, pets are not cheap.
They are not.
So to be able to provide for them after, if something should happen to you, who knows? That's something to think about. But what happens when you don't have a will in place?
As far as with your pets?
Or just in general. So if you pass and there's no will in place, what happens?
So if you have nothing in place, which is very often the case, and again, I'm meeting with people all the time that come in with a loved one that's passed, and that's a very confusing situation then, because they had nothing in place. Oftentimes, if they had nothing in place, you also don't know really necessarily what assets they had, where they're held, so that becomes a real kind of fishing expedition to try to figure everything out, where it is, who the beneficiaries were, if any. But if you don't have any type of estate plan in place, you're still often going to need some kind of personal representative, and so that leaves the opportunity open for people to fight on who's going to be in control. As far as beneficiaries, if you don't have any type of will in place, anything that's in that kind of probate estate, that passes pursuant to what's called intestate succession. So it goes how the state of Illinois says it goes. And again, that's something that also people often don't understand, and really, I think, understandably get confused or don't know how things would pass. One common one that I see is a married couple. They'll often think, well, I don't need an estate plan. If something happens to me, it's just going to pass to my spouse. So what's the point? It'll just go to them and then they can handle it. But Illinois law for intestate succession says that if you're married and you have children, your estate actually goes half to your spouse, half to your children. So that can lead to a lot of unintended consequences as well. That's why, at least at a baseline level, you want that will in place to make it clear how you want things to pass.
Yeah, absolutely.
So what do you feel like is the best first steps that someone needs to take when it comes to estate planning?
Really, the first step is to just set up that consultation, either with me or another attorney, and just go in with your concerns and be prepared to kind of talk about who you want to be in charge, how you want things to flow, and really have a kind of at least a general understanding of your assets and how they're held, so we can start talking through that, and then I could give them ideas on this is what I think you should do. I'll ask them kind of follow-up questions to a lot of things, specifically with beneficiary designations. They'll often say something like, well, I wanted to go to my wife, wanted to go to my kids. Was like, well, are any of those kids minors, or those kids disabled? What if something happens to one of those children? They predecease you, they die with you. Do you want it to go down to their kids if they have kids? Do you want it to go to your other kids? Do we need to set up trust for grandkids? The beneficiary part is often a lot more complicated than you would think, because you really need to think through all the contingencies, so that if you have this plan in place but then something's happened, it doesn't blow the whole plan apart. You still have it structured to handle a lot of different situations.
Yeah. Good. Okay, I'm going to say something because I think this is crazy. And if you don't have this thing in place too, there are people out there, they're like vultures, right? If you go through probate, is this true? This is just something I read somewhere, but is it true that people, go to these probate to court and claim that they have some kind of, you have a debt against them and you have to pay them off? Is that...
It can certainly happen, and in these estates, of course, I'm like the doctor that thinks everyone's sick, but I see all the bad situations in estates, because that's why people come to us after someone's passed away, is something bad's happened, they need an attorney. But yes, so it can really, people can kind of come out of the woodwork, try to claim things, claim your own money, claim they were a beneficiary, claim they were an heir, really inside probate or, outside too. Within the probate court, though, that does give an opportunity for people to come into court, try to challenge. I don't know if you've ever seen them in the paper, but the Probate Act requires publication in the newspaper, so you have to give notice of that estate, so then everyone kind of knows this estate's in court. If you have a claim, come make it, and that holds it open for 6 months at least, where they can come make that claim.
You're kidding me. So if your estate goes through probate, you don't have an estate plan set up,
right,
or a will, it goes through probate, it gets announced in the newspaper.
That's correct. Yeah, once a week for 3 weeks it gets published. That's also not cheap either, to publish things in the newspaper. Yeah.
So that entire bill comes out of your estate.
That's correct. Yeah, yeah, the court costs, the publication fees, the attorney fees. You have to have an attorney represent you in a probate as well. So it costs a lot more money to go through probate than it does to get things set up now.
Man.
So, Evan, you've been doing this for a long time. What do you feel like is the most common mistake or belief system that people have when it comes to dealing with stuff like this?
Correct. That's a great question. And the most common mistake, and kind of also the most common belief, is thinking that just because you have the documents in place, you've got everything settled, everything's good to go. I see attorneys make this same mistake over and over again, where people have a will set up, people even have a trust set up, but they've not properly structured their assets to go hand in hand with those documents. Setting up a trust, but then not properly funding it, putting assets in it, or making it the beneficiary of assets. It's like building a house and never moving into it. You've got this shell. I even met with an individual not long ago that had this family member, great estate planning binder. I was even a little jealous. It was prettier than mine. Really nice padded binder, trust, will, powers of attorney, everything in there. I'm like, man, this looks great. Looks like you're well set up. Let's talk about the assets. Nothing had been funded into any of this. It was actually going to go to probate if we didn't do something else, even though they'd had this great estate plan done. That additional work of making sure that trust was funded was not done. So that's the most common issue I see over and over again, is not just people not having a plan, but not having a plan in place, but having not actually executed it properly and structured their assets properly to make sure probate's being avoided, and their other concerns are addressed as well.
Something just came up when you were saying that for me. What does it mean when it's not funded? What does that mean? Yeah, so the funding, if you're setting up a trust, and there's many types of trusts, I could do a whole podcast on just trusts, but a trust is essentially a fiduciary arrangement. It's a separate legal entity that you're setting up. I mostly do a simpler type of trust called a revocable trust. That's one that the person creating it can change it, amend it, over time,
it's mainly used for probate avoidance and to more specifically provide for distributions, protections for disabled beneficiaries, protections for minor beneficiaries. But the funding of that trust consists of making sure your assets, if something happens to you, are going to flow through that trust. And that can be done, several ways. With real estate, we want to deed it in the trust so that the trust then owns that real estate. Since that trust doesn't die, when something happens to you, that real estate's sitting in that trust. It doesn't have to go through probate because it wasn't in your name. With accounts, on some accounts we'll change ownership to the trust. Some accounts you don't want to do that, like tax qualified accounts, you don't want to change the ownership, cause that taxable distribution. So we'll make maybe the trust the beneficiary in certain circumstances. So things like that. So when we talk about trust funding, it's just making sure everything's going to flow through that trust if something happens to you. And that's what avoids the probate.
Interesting. So you mentioned trusts, and trusts are different than wills.
Correct. Yes.
Okay.
So I mentioned the will as kind of that baseline estate planning document. So everyone needs that will, but then as we talk through things, often there's more that you need. There's more that needs to be done to make sure all your goals are being met, whether it's protecting beneficiaries, probate avoidance. And so that trust is usually that additional document that helps that. So a will is just a declaration. You're just stating what you want. It doesn't actually do anything with your assets. It doesn't change the structure of them, how they're owned, or anything like that. And that's why it doesn't do anything for probate avoidance. Whereas that trust, it's not just a declaration. It's a separate legal entity that allows you to structure your assets through it, allows you to provide for greater leeway for contingencies and probate avoidance.
Got it.
Wow. So let's say I, receive an inheritance. Is that taxed? How does that work?
Taxation is a great question. That's something that often comes up, and if it doesn't come up, I bring it up in any meeting. So there's several taxes to think about when it comes to estates, comes to estate planning. As far as an estate tax, the state of Illinois and the federal government both have an estate tax. There are some states out there that have an inheritance tax, which means you get the money, then you, as a beneficiary, then you pay tax on it.
Like income, right? Like it's income?
Kind of like that, yes.
Okay.
And so with the estate tax, though, we look at the value of your estate. And once your estate is worth over that threshold value, it's taxed on every amount over that value. So that tax, the estate tax, only kicks in against your estate if your estate is worth more than those thresholds. At the state of Illinois level, that's currently $4 million. At the federal level, it goes up every year, but I believe it's $12.92 million. It's significantly higher for an individual. So there's going to be no tax if you're under that amount. If you're over that amount, there are things we can do through estate planning to reduce your taxable estate and also then potentially even eliminate that tax. Another tax you have to be aware of is on any tax qualified accounts. If you're a beneficiary under those have never been taxed, so they're going to be taxed when you receive them. So we can't necessarily avoid that tax. Depending on if you want to take a lump sum or stretch it out, though, you can reduce your taxable obligations there. So those are the most of the tax questions I get are either on the estate tax or with tax qualified plans.
Okay, so when you say that, you're talking about like a Roth IRA or something where you haven't paid, or the tax, that kind of
like
an
a
account,
traditional
like a
IRA,
retirement
where
account.
you've paid in tax free. The government hasn't gotten their
Got
money
it.
yet. They're going to get it eventually. So
Okay.
all we can do is later on maybe stretch out those distributions when they're coming to you. If you're a spouse, you can often roll it over and keep getting those tax advantages in that way. So that we can't avoid, but we can try to structure it to where you have less of a tax burden.
Got it. What happens when someone dies with a lot of debt and their estate doesn't cover the debt? What happens?
So essentially an insolvent estate, and that does happen, and that's a situation where, we talk about probate being a bad word. Sometimes it may be necessary in certain circumstances, and that's one of them where there's a lot of debts. You may need to open up a probate, allow all those creditors to file claims, and then there's an order of priority in which they can be paid. And if there's no more money after the top priorities, then that's that. The rest of them, it's almost kind of like a bankruptcy. They're just, out of it at that point. Some other reasons you may need a probate is if your death was the result of an accident or something like that, there's litigation involved, or there was ongoing litigation when you passed, you may want that probate estate, that shell, to have that representative appointed to handle that, to be a legal representative for that lawsuit. And so that's some reasons why you may want that probate estate. But with that debt, sometimes it's good to have that probate just to get the top priorities paid, and then the rest are just barred forever after that. There's no money left to pay them. One question I do sometimes get is people may be afraid to put someone in charge because they don't want them to be responsible for their debts if they have debts, but a personal representative is not going to be personally liable for any type of debt unless they like misuse funds or something like that. It's only what's in your estate that's subject to that debt. Who you're putting in charge doesn't take on any liability.
So
or
they
anything.
don't consume that liability.
Not
then
at
when
all.
They,
No,
okay.
it's all limited to that estate.
Wow. Interesting. I didn't know
That's
that.
interesting. Another question I have is like, can you leave an inheritance or leave it to like a charity or an organization, like that kind of thing?
Absolutely. You can always leave it to charity, foundation, church. It doesn't have to be a person. It can be any type of legal entity as well. And I see that very often. I see it some as like a primary beneficiary, kind of like a front line. I want this amount to go to my church, this amount to go to my kids. I also see it often as a contingent beneficiary as well. If something's happened to this person or these people, leave it to my church, leave it to this charity. I also always provide in my estate documents what's called a remote contingent distribution. It's kind of like a disaster provision that just says, what if something's happened to everybody that I've mentioned in here? What do we do then? So it's not up in the air. And oftentimes people may list out some charities there as well. So I see them in the documents a lot, just in different kind of structure or order of distribution. Yeah.
Yeah, I wouldn't even think about that.
Right.
If something happened to all of us, what would happen then?
Yeah, and that's
Wow.
something a lot of people haven't thought through, and it's obviously something you hope never happens either, but plane crash, car crash, a lot of things that can happen that really change everything, and you want to still have provided so that it's not a question, it's not fought over, it doesn't end up going to the state or anything like that. So
Right.
want to have a plan in place for all the contingencies.
Yeah. So you mentioned power of attorney, and I know there's kind of a difference between like a medical, what is it, somebody that has
Like a healthcare power of attorney.
power of
Yeah.
attorney versus your estate power of attorney. And can
Yes.
you maybe explain what the power of attorney, what role they play?
Yeah, absolutely. So estate planning is not just about, preparing for your death. It's also about preparing for incapacity. There's many types of powers of attorney, but the two you're typically going to see in estate planning are that healthcare power of attorney and that durable power of attorney for property, which is also called the financial power of attorney. So in that healthcare power of attorney, you're appointing who's going to be your healthcare agent, who's going to make healthcare decisions for you if you get to a point where you can't make those decisions. In that financial power of attorney, you're appointing who's going to make financial decisions for you if you're not able to. And then those powers of attorney die with you, so they're only good for that period of incapacity. Once you die, we're looking at your other plan at that point, your will, your trust, and things like that.
Wow.
The importance of the healthcare power of attorney beyond just who's going to be in charge, who's going to make that decision, it also contains an advance directive, which lets you kind of choose your end of life desire if you so, choose to do so. You don't have to make that decision, but it often helps out the family to know what you want. So you can choose, if you're in an irreversible, incurable condition where a doctor's deemed you're not coming back, oftentimes it's kind of a comatose situation. Do you want to be artificially prolonged on machines, or do you want to be made comfortable and allowed to die naturally? So you can make that decision in that document.
Wow.
For yourself. Yeah.
Yeah.
That's important.
Yeah.
Yeah.
Wow.
Man, I feel like there's so much more we could dive deep into, but
Really, every topic that we've talked about we could dive in deeper to every single one of them.
yeah. And so to close this podcast episode, because I know your time is very important, I just wanted to thank you, first of all,
absolutely.
for being
Thanks
on.
for having me. Yeah.
But I also wanted just to ask you, if you were to leave somebody with advice, like what would be the one thing today that you would want to leave them with?
The one piece of advice is whether you have a plan or not, you always need to be thinking about contacting an attorney, if you don't have a plan, get one in place. If you have one, maybe it's time to review it. Have your situations changed? Have you had life changes? Have your assets changed? And even if they haven't, it's a good idea to, look at that plan every 3 or 4 years anyways. So my advice is everyone needs a plan. And even if you have one, you need to be reviewing it to make sure it's still, meeting all of your goals.
Oh yeah, we've heard horror stories about that.
Absolutely, yeah.
Not reviewing and keeping it updated for sure. So.
I think this is good too, because I think, a lot of people think estate planning is just for like the rich, but really it's for everybody.
It is. It is for everyone.
They need to be thinking about it, and to make those steps and plans are super important.
Yeah, it's not just about your assets, about having the right people in place. If you're incapacitated or pass away, it's about protecting children, protecting pets. There's a lot that goes into it, and it is for everyone.
Yeah, not the rich, but not just the old too.
Yeah,
that's another misconception too.
So any age, any asset level. That's right.
Yeah, absolutely. Well, thank you so much.
Thank you all for having me.
Being on today. If people were trying to reach out to you or find you after this episode, what's a good way for them to reach out to you?
Really, the best way is to reach out to our office, to call us there. You can ask for me or ask to just leave a message for me. You could also email me. It's etaylor, so ETAYLOR at lblf.com. That's for Lawler Brown Law Firm. So either way would be great. And I'm happy to answer any questions anyone has.
That's great. And we'll link that in the show notes too, so people can get a hold of you if they need to. But before we close, we kind of have exciting news. So last episode, we mentioned that we are doing a workshop this fall. It's called the Legacy Series, and we're having some presenters come in, and we're excited to announce that Evan's hopefully going to be with us.
Excellent, yeah.
For our series, and what we want to do is really set people up so they're prepared to leave a legacy.
Always happy to talk about what I do and share the knowledge, because my hope is that everyone is preparing for their legacy and passing it on, making it as easy and seamless as possible. The last thing I like is having people come in where that's not happened and having to go through that. I'd much rather see it done properly on the front end to avoid all those problems later on.
Absolutely. Well, thank you again for being on today.
Yeah, great
This has
being
been
here.
great.
Thank you so much.
Yeah.
So Jill, where do we go from here?
Be sure to check out our show notes for this episode, and also be sure to follow us on social media and subscribe to our newsletter. We'll see you next week.
See you next week.